parties will approach plaintiff on their side, defendant on their side. Ready on the jam.
And I'm still typing notes. Okay, this is case number 25-00009, GC Benet Brown versus Meyer. Store number 231. Okay. What's your name?
Benet Brown. Good afternoon, Your Honor. Kelsey Hall on behalf of the defendant.
Okay. Well, now, from what I see, there's a lot going on here today. You have a lot of motions. And then you have a summary disposition motion also pending.
Yes, Your Honor. I don't believe you.
But I don't think it was noticed today.
Correct. We did not receive a hearing date.
Okay. So, ma'am, would you like, now, I mean, if it depends if you people are ready. I mean, I could hear it unless you want more time on the summary, because it was not noticed. So it does not have to be heard today.
But I have 3 other motions that were.
I know. I'm just saying we got a whole we got a whole bunch of things going on here. Did you ask for did you call my clerk to get a date?
I believe we did. I think that we were supposed to get a date, but it wasn't set. It was in the notice of hearing to be provided by the court.
Okay. And we don't just do that. You got to call her.
Correct. Yes.
And you did call?
Yes, I believe we did. I can double check with my assistant, but
because usually if you call, they'll pull the book right away and just give you a date.
Yes. I don't know. All I know is that we hadn't received a date for it. The notice that we got was for a motion to compel for today, which I believe is our motion to compel.
Okay. I see on here, I just see motion. Then it says motion to compel. All right, so let me see what I've got here so we can see what Ms. Brown does have. I think I've got, well, there was a motion in limine that was filed on July 29th. That was also filed on May 19th. There was a motion for ex parte protective order to limit the defendant discovery that was filed on July 29th. And then there was an objection to an exhibit list filed on 6/2. Then there was a motion seeking relief to rein in defense counsel's overly broad request, but that was withdrawn.
Excuse me, I have all 3 here that I filed. I called it got a hearing date on.
All 3 what?
All 3 motions that are right here. Those others were not motions that I called and got a hearing.
Okay, well, which ones do you think are supposed to go today?
Okay, I have a hearing for a protective order limiting defense's discovery. Okay.
That's one I read. Mm-hmm.
Okay, and I also have one because compelling them to produce.
Sign authorization?
Compelling them to produce discovery responses, which.
Okay. Well, you have plaintiff stipulated order compelling discovery responses, which appears to be a motion to compel.
Yes, ma'am.
Okay, so that's 2. What's the third one?
And the third one was, or is. And the motion to compel got quite a few documents attached to it. And the third one was the protective order limiting discovery.
I got that.
We already had the deposition. Okay.
Okay, I got that. Then you have this motion to compel.
Motion and limit.
Okay, that's one I read. Okay, and so you had one that was withdrawn. The only other one was a motion to compel signed authorizations.
I didn't withdraw these, ma'am. These are all here.
I didn't say you withdraw those 3. I said you withdraw this motion seeking relief to rein in defense counsel's overly broad request for medical records.
Yeah.
That you withdrew.
Yeah, because that actually wasn't a motion because at that time I didn't know I had to call, submit a hearing form and get a date.
Okay.
That's before I knew the procedure.
Okay.
So
what about this motion to compel sign authorizations? That's not one you.
I believe that's my motion, Your Honor.
Okay. That's yours. Okay. Yes, because it's defendants. Okay. I have a list here and I'm just confusing myself. Okay. So I got your 3.
Thank you.
Is yours going today, the sign authorization? Was that notice for today?
That's the notice that we received, yes.
Okay. So that one's going too.
I've got a question about that.
Yes, ma'am.
They want sign authorization, but yet they just filed a motion for summary disposition.
Okay, what's the question?
Well, the point I'm trying to make, I have a motion here limiting what they can request. Okay, when I was at the deposition, they brought me some authorizations, one of which.
So which one do you want to argue now? The motion to limit the discovery? That's the one you're talking about now? Plaintiff's motion for ex parte protective order to limit the defendant's discovery?
Yeah, I guess that would be it.
Or is it the motion in limine filed on 7/29? They both filed on 7/29.
Well, the motion on lemonade was to prevent them from acquiring all these witnesses.
Okay.
To limit the
Well, you want to do that one first?
what the amount of witnesses.
Yeah. Which one? We got to do something. So let's just start with something.
There.
Okay. So that's a motion in limine where plaintiff seeks to exclude the defendant from calling various experts because they did not treat you.
Yes, ma'am.
Okay. And so you've objected to witnesses from Peretta Center for Orthopedic Surgery, Dr. William Kesto, and Beaumont Medical Group, who are providers for plaintiff. So you don't want them called. And then, did you file a response to it?
No, Your Honor.
Okay.
As Your Honor is aware, we file a witness list, right, in accordance with court rules, listing every potential possible witness that you could call. Obviously, that gets whittled down by the time of trial. And, we put on your witness list as who you're able to call. We have experts that are listed on there that would be potential experts that we could call if we choose to retain them. That would be relevant to the claims that Ms. Brown is making, in addition to any medical providers that would have been listed on the medical records that we did receive. I think that it is obviously better to be overrun rather than underrun on a witness list, especially if the case is going to go to trial, to make sure you have all your bases covered. And I believe that that's in accordance with the Michigan court.
Well, she argues that since these folks, quote unquote, did not treat her, that they're precluded. That's her argument. They should be precluded from testifying. But the way it works, Ms. Brown, is that so you're alleging that you had injuries as a result of some type of improperly stacked display that fell on you at Meyer. And you're alleging that they were significant injuries to like a rotator cuff. Okay. All right. Let me finish. I'm not saying they weren't.
I have an argument here that I would like to see.
About what?
About the witnesses.
Okay, well, go ahead.
Okay, I'm gonna just read. Okay, because that works better for me. Okay. I said, now here comes the plaintiff, Brene Brown and per, and I seek relief from the court. Please exclude any testimony from persons listed below. They are irrelevant and could unfairly prejudice the court against the plaintiff. The plaintiff feels that this is a tactic by the defendant's counsel to waste the court's time and cause plaintiff to incur unnecessary costs. To grandstand, in other words, the plaintiff states, none of these experts are necessary to this case. They have never met the plaintiff, and any so-called evidence or testimony they are likely to give would be speculative, based on conjecture and generalization, influenced by bias, swayed toward the defendant. Plaintiff states these so-called experts don't know the plaintiff, never examined the plaintiff, or ever treated the plaintiff for any malady or condition. For these reasons, the plaintiff is requesting the honorable court remove them from the witness list and disallow any testimony they are likely to get. And you did have the list of the doctors.
I did. And did you want to respond to that since she read it? And
Yeah, I mean briefly, Your Honor. Those I believe. Obviously there are expert witnesses listed on there that if we choose to retain, would be allowed under the court rules. It says on there that we haven't retained any of them yet. It's my understanding. I'm familiar with the case. We have not retained any of those experts yet. With regard to any of the other providers, any medical records that we have or Miss Benet would have provided, those doctors would have been listed on those medical records.
okay, well, some of them are your witnesses, and it looked like you objected to them calling some people who did provide services to you, such as Beaumont Medical Group. Didn't you go there?
No, I did not, I didn't include them. I only included the doctors per se. They had a list of specialists and all kinds of people that were going to pull from, potentially calling at a
Okay, well, let me tell you what I can't do is I can't just say blanketly that they can't call those witnesses because they didn't evaluate you. Because the way it kind of works in this kind of case, when you have injuries, they can look at medical records. An expert could just simply look at your medical records, which I'm assuming that they have gotten those, look at them and give an opinion that may be different than what's in the medical records, or give an opinion that says, yes, she suffered from this, but it's not from this injury. It's from something else that's maybe pre-existing. I don't know what the records say, but I can't tell them that they cannot retain the expert to look at the records. And if they, and if they come up with something that's relevant to them, they could call them. But without knowing what the expert is going to be looking at and testifying to, I can't just blanketly exclude them saying it's irrelevant simply because they didn't evaluate you personally.
But I did include some experts and doctors who did evaluate.
And they could probably call those if they wanted to, but they have a right to try to rebut anything that you do present from your own doctors who evaluated you.
But just from the fact, Your Honor, that they're filing a summary disposition without any evidence. Okay, they're just saying, I don't have enough evidence, which I do. I have documents containing.
Well, we're not getting to the summary, so I don't know who has what evidence just yet.
Well,
yeah.
But I won't even speak on that yet.
Okay.
Leave that alone. So, okay.
So basically, those providers that they may choose, and like she said, they haven't even decided if they're going to use anybody yet. It could be relevant that even though they may not have treated you for the specific injury, but as I said before, they could be looking at injuries that may be pre-existing that they may contend don't relate to this accident. I don't know. There's no requirement that any expert witness has to treat you in order to give an opinion, because they can base an opinion off of other facts, other records. So just to say, well, we're going to keep them out simply because they have not specifically treated you directly is just not valid. That's not a good basis. As you have the right to call a witness that did treat you to say something, they have a right to call a witness that maybe did not treat you, but could look at the records that of someone who did treat you and give an opinion that may be more beneficial. And when you say, it's going to prejudice the court against you, that's what witnesses do. That's the whole point of a trial. One side's going to bring a witness one way, and the other side's going to bring a witness that may prejudice against what the other side has put forth. That's normal in a trial.
But isn't it about getting to what the truth is?
Yes. And if they call a witness that says something different than what your witnesses or your experts might say, the jury or the trier fact, if it's a non-jury trial, has to make that decision. Who do they believe? Right. What's correct? What really happened here? And they don't have to believe either expert. They can just say they're both full of nonsense and go from there. Or they can believe one partially, and some of what that one says, they don't have to believe all of it. Or they can believe some of what the other one says and not all of it. And that way they make their decision, based upon, let's just say, a hodgepodge of beliefs from each expert. Or they could just throw it all out. Everything the one expert says or everything the other expert says. And that's the beauty of how the process works when they're talking as to who they believe. And they do their job. Usually jurors do at least pretty well, because they sit and they talk about why they don't believe this person, or that evidence didn't gel, or he didn't seem proficient on that. So I kind of don't believe that, but they have a right to at least bring that. And, the argument could be made to the jury. Well, he never saw her. That's something that you can argue if you wanted to. But they got to come back for that. Well, we don't have to. You're doing you can give a medical sound opinion without doing that. And the witness might say, sure, I can. So, these are all questions for a trier of fact. So I really cannot grant that motion and deny them the opportunity to call a witness, even though they say they may not.
Right.
Okay. So that motion in limine is going to be denied for those reasons. So your next motion is for a protective order to limit discovery. You had objected to various exhibits. Is that correct?
No, it wasn't that per se. Can I read this?
Okay. Well, I had my notes said employment records, tax returns, educational history, medical records.
Right, all that. That doesn't pertain to this incident.
Okay. So I had medical records that don't reference the January 31st, 2022 incident. City of Detroit records, workers' comp records, medical records, requests, a decade worth of those, and Social Security records, state of Michigan records, and IRS records or Treasury records. And the defendant did not respond. Presumably, I'm assuming that whatever they're trying to do would show some type of possible pre-existing injury or some way trying to mitigate their damages. What do you want to say?
Yes, Your Honor, and I think this goes towards my motion to compel. This motion that she had filed, I believe it was like back in July.
Yeah, it was.
Yeah, so some of that has been resolved, and she has agreed to sign some of them. So the only ones that are outstanding is medical records from University of Michigan Medicine, Dr. Wolfson, the Michigan Department of Treasury, Walgreens Pharmacy, and Social Security Administration records. So those are the only ones that are outstanding. And that goes to my motion to compel. As Your Honor stated, under the court rules, under MCR 2.314, we are allowed to, these medical records, this information is discoverable when you put a mental or physical condition into question.
Yeah.
Can I just speak when she gets finished, please?
Mm-hmm.
Right.
When she gets finished. So you said medical records from University of Michigan, the Department of Treasury records, Walgreens, and Social Security are still outstanding.
And Dr. Amy Marie Rolston, Rolston.
Okay. All right. And so that goes to your motion that you're seeking, which is to compel authorizations for that information.
Yes.
And she's obviously in this motion requesting that be limited by protective order so you don't get the authorization. Okay. And so medical records, Treasury records, Walgreens, Social Security, and Dr. Wollstone. Why is it that you feel that they shouldn't get those?
Deposition on the 12th, Miss Hall brought me an authorization to sign off on for Social Security records from the date of my birth, 1959, until present. That in itself shows that they are predatory. They just want to try to bring any of, at that point, I'm a baby. So what you're trying to find out is about my parents.
Okay. Maybe. Okay, hold on. Let's stop at that. Why would you need them from way back at her birth?
That's standard. When you fill out the Social Security Administration form, it's standard to do it from the time of birth until the present date. Obviously, I I would be surprised if the Social Security Administration
has anything.
when she was born, right? But
Probably don't.
right, but that's standard to put on the form. That's every case that I've ever seen. That's just standard with on the Social Security Administration form.
Okay.
Yeah. I don't feel they need to know anything about my sources of income.
Well, ma'am, aren't you asking for damages?
Yeah, but I have proof for that.
Okay, so they not entitled to see what income you have and what you might be worth.
But my damages have nothing to do with me being on Social Security. Okay, I could be homeless. I could have been a homeless person that walked into Myers that day. Would that make me any less valuable because those items I picked up one and they all fell on me?
I'm not so sure they're going to how valuable you are. Tell her why you seek. Let's hold on. Why are you seeking the Social Security records?
Sure. So first of all, Miss Brown testified at her deposition that she is currently on Social Security disability, right? So I think that's important for us to see where other forms of income are coming from, what she was actually disabled for, and how much she is receiving per month. Additionally, I think she's also making a claim for economic damages,
right?
And if she has income from other sources, this might reduce her need for certain damages, or show, that maybe she was actually working during the time of the accident or had other things going on. We need to be able to actually verify her testimony. And I think that, that obviously would go towards credibility, character evidence, all that type of stuff on the stand if trial were to come.
I was not working.
Okay, ma'am, but here's what you got to understand. A trial is supposed to be fair to both sides. So, and the gathering of discovery is supposed to be fair to both sides. So even though you have documentation that shows maybe that you weren't working and that, you were aggrieved to a certain amount of damages that you're looking for, they do get a right to try to limit your economic recovery. And whether or not you might have been getting disability for something, if they can see that and connect it to the type of injury that you're saying you have now, that would be very relevant to them. And that could be a defense. So they have to be able to look at these things to see. And it's not surprising anytime somebody has filed a claim for money damages or economic damages that you open up to scrutiny your income.
Yeah, but I didn't file any claim to recover lost wage.
Okay.
Because I wasn't working.
Okay, but how do they know if you're working or not? They don't know. And you're looking for some amount of money. And if you're receiving disability, it could go to offset some of your claim. It may not. But they at least have a right to look into that to determine if they think they have a good defense there. So that's why I know it's hard when you're the plaintiff to understand why the defendant wants to look into. But anytime you bring a lawsuit like that and you're looking for money, they do have a right to try to develop a defense to limit that. So those things that she's asking for are not unreasonable. Now, I know you have signed off on some things, and that's kudos to you. But if you're looking for the Social Security, she says she's also looking for the Department of Treasury. That would be income tax type, state income tax documentation.
Yes, Your Honor. And just briefly, Michigan courts have addressed this issue. The Michigan Court of Appeals has held that tax returns are generally discoverable.
Oh, yes, they are. They are. And then what's Walgreens?
Walgreens Pharmacy, it would be for her prescriptions.
Oh, okay. So whatever meds she might have taken as a result of this injury.
No, she's talking about now.
Or otherwise, because I don't know what your injuries might be.
Injuries resolve themselves within a year, Your Honor.
Okay, but that's what you say.
But I'm the person that got hit.
But ma'am, this is a lawsuit.
They're just suing me, though.
They're defending. against you suing them. That's the thing. They don't have to take anything you say as true. Look at it that way.
Dr. Amy Ralston, I will not give them any authorization to that. That is my current doctor for my current condition, and I will not.
Okay, ma'am. Then I can certainly limit your request for damages if you do not do that.
No, I will not. That is what my condition is now. That was just diagnosed in 24.
I don't know what your condition is, but they have what I think it's kind of lost on you
It's
is
the deposition I told them.
okay, but I think it might be lost to you that just because you said it doesn't make it accurate. They have a right to look into it.
I'm gonna get my cancer doctor's information.
Okay.
They're not gonna find out what I've been going through for the last year. I don't need these hawks trying to display all of my personal information. Excuse my raising up my voice
When you say
and making it personal and privileged to the general public because it will be known as open to the public.
well,
At that point, it
I'm
will
not so
public.
sure that that's accurate because we can limit it to just them seeing it. And just because it's there doesn't mean that they will use it. But what they do have a right to see is I don't know.
It has nothing to do with anything that's pertaining to any injury I have had in the past,
Okay.
period.
All right. Well, I don't know if it does or
Well,
not.
Author-
And they well, ma'am, let me tell you this. Last I checked, I have the final say, not
Okay.
you.
Last I
Okay.
checked, you're
That
probably right. Girl.
okay. But I fully understand your position. And I fully understand why you feel that way. But I'm just trying to say that anytime you're raising an injury, they have a right to look. Now, that doesn't mean they're going to use it. They might look at it and say, you know what? We're looking at this and we don't really think this connects to that.
Don't need it. They just.
Well, why do you think you need it? Let's listen to their position. Why do you think you would need her records regarding anything such as cancer, if that's what she's been treating for, to relate to damages here?
First things first is to mitigate damages, right, Your Honor? So the very first thing is to make sure that the injuries that she's claiming that happened at Meyer are actually related to the incident and they're not related to other injuries she might have sustained or other medical or health conditions that she has ongoing. Additionally, pre-existing injuries or health issues, right?
Mhm.
So if there's any, I feel for Miss Brown. I do. I understand.
I understand what she's
that
saying.
Cancer is a very difficult thing to go through. Unfortunately, Ms. Brown has brought this lawsuit forward, and so we have a right to see pre-existing. How long has her cancer dated back? Has that had any effect on how she's healed? Has that had any effect on the injuries that she's claiming she sustained at Meyer? So that's the reason for it.
Yeah, and let me say this to you. The way it works, Ms. Brown, is discovery is very broad in civil cases. And just because it's broad doesn't necessarily mean everything that is obtained is used. And it doesn't mean everything that is obtained is necessarily admissible. That's down the road at trial. But discovery is very broad, especially when you're raising injuries. And you might very well be correct that maybe none of this predates your injuries and this is something subsequent. Maybe it has no effect on the amount of damages you're seeking, but they do have a right to look into that. And so when you do bring a claim, you're opening it up to everything.
I can authorize that because I just got diagnosed in 2024. I will not authorize it.
All right. So what next?
Let's go with their
I'm just saying medical records from U of M. I don't see why they're not all of this appears to be relevant to me.
U of M is my cancer doctor.
Okay, ma'am, did I just not say that when you sue for damages, you open up all of your medical history?
Not going to give them that information.
Okay, well, if the court orders it, which I probably will, you have a choice whether you're going to comply with the court order or not. Surely it's an order. If they can then, if you don't comply, ask for a sanction. then we'll deal with that if it gets to that point. The sanction could very well limit your ability to recover anything in the case. But that's how it works. It appears they're not asking for anything get a chance to look at.
Why should they be able to look at? They want to know if I'm gonna die soon. That's really what they want to know.
I don't know what they're.
They know what they want to know. They want to know what stage cancer I have. They want to know how what's the odds of this lady live to even get a recovery. So if we can just drag this out as long as we
Now,
can.
let me tell you.
We can hear you all down the hall.
I wasn't yelling at the judge. I'm passionate.
I understand,
And
but
I
you're yelling.
apologize.
That's okay, but you're yelling. Just if you could bring it down some. Thank you.
Thank you. So the bottom line is they can't drag the case out. I have scheduling orders. We will go to trial on a specific date. There's no basis for them to quote drag it out till quote you die. That's not going to happen. You're here. You seem to be in good health. This case is moving right
I just
along.
look good. That's all.
Well, you sure
I
do.
have to give that to my parents.
And
I'm 65 years old.
you look great.
I look good.
You sure?
Yeah, I look good under any circumstance. I have been through a lot. Cause it's my second cancer. But the thing is, I'm a God-fearing woman. I'm not gonna say I'm a Christian because these alt-right people have tarnished the name of Christian. I'm a follower of Jesus Christ.
All right.
Okay, and that's why I look like this.
Well, you do. And we're going to make sure this case gets resolved it'll be before a year. She can't drag the case out any kind of way just to see if you're going to survive or not. And we pray that you do survive and that this is all going to work out.
I mean, some people think today is supposed to be the day of the dog going up to the sky. They got all these people all over YouTube talking about this is the day. So you don't know what's going to happen today. I recommend everybody, when you leave here, be careful because there's a bunch of fools out here think this is the day for the rapture. So just everybody be careful because you got people out here that really believe that, just like the people that were waiting on that comment, that hell box.
Oh, yeah.
They're going to catch a ride. They had $5 in their pocket and they all had on their Nikes waiting, So some people just get so engrossed in conspiracies that they don't think for themselves and they just follow the group. So it's just a bad time out here. But if you can, Your Honor, I'm sorry I deviated. Before you make your decision on this order, can we hear about them not complying with my request for discovery?
Well, that's a different one.
Well, why should they be able to?
Well, we're going to hear yours. If you're saying they didn't comply with your discovery, we're going to get to that. I can only do one at a time. So on this one, I find that, and this is really two of them because they kind of correlate. Your motion for protective order, that's going to be denied, as I do find that the U of M records, the Department of Treasury, Walgreens Social Security, and Dr. Walston, which are the remaining items, are really relevant to possible defense. Discovery, as I said, can be very broad, although it doesn't necessarily mean things are going to be used, and it doesn't necessarily mean that things are admissible. But I think these things are discoverable due to the nature of the type of damages that you've brought forth in your complaint.
My original lawyer was asking for $500,000.
Well, ma'am, if you're asking for $10, they still have a right to look into finances to see if you're eligible for the 10. That's just the way it works. And so conversely, wait a minute. So conversely, the plaintiff's defendant's, motion to compel is granted for those same documents.
Your Honor,
Mhm.
they're asking for a deposition, summary deposition. They're saying they're not going to use any of it.
No, I don't know what they're saying because I've looked at it fully, but generally it's saying that, hey, there's no questions of fact and you don't really have not presented enough evidence to make a question of fact for trial, or that there's some kind of legal precedent there that controls it. that says they're entitled to judgment as a matter of law.
And if they're already saying I don't have enough evidence, why should they be?
Because until the motion is decided, the case is still moving forward. That's how that works. So let's just say we grant their motion down the road, then the case would be gone and nope.
Still have had access to my privileged information.
It may be or maybe not, because quite frankly, depending on when the motion is heard, they may not even get the authorizations in time and have been able to get the document, because documents from these companies take a while to get. The motion might be heard before any of that actually happens, in which case then they don't have those things.
Well, what motion are you speaking?
Her motion for summary disposition.
And I'm
If
ready
you're
to defend
amenable,
it.
if you're amenable to hearing it.
I'm ready to defend it.
Okay. So
That's why I'm saying that these authorizations are moot because they're going for a summary disposition.
okay, no, I got to resolve. The way it works, I have to resolve things on my docket, every single thing.
Okay.
Because if this motion, you might be right. It might very well be moot if the motion's granted.
Okay.
But if the motion's granted, your case is done, that your case is over, then they don't care about this. They're not going to.
I mean, moot on their part, that mine.
Okay.
I plan on winning.
Okay, but let me say this. If their motion is asking me to dismiss the case and I grant it,
Well, then, yes, I know that it's over there, but
right.
I have a defense for that.
Yeah, we'll hear that.
Great.
Sure we will.
Thank you.
Absolutely. But in the meantime, the case is still pending and I have to move forward and resolve these things, or else someone in the civil division downstairs is going to say, well, what happened to this motion? There's no order here. So I have to have an order, resolving each one of the things so that we make sure the case is decided and it's on track. Okay. So we've got denied on this. We've got granted on that. Then we've got your order,
What did you grant?
their motion to compel the authorization, which is the same as you being denied the protective order so that they can't get the authorization. Okay. So then we got your motion, which appears to be a motion to compel some discovery.
Yeah, they never complied, Your Honor.
Okay, so what did not they comply? Is there a whole list of these we got to go through?
Personal discovery, and they used a lot of semantics, a lot of legal jargon, and a lot of legal acrobatics not to answer my question.
Okay, so let's see.
Raised some of them and resubmitted them and to the court.
You had number 5, you resubmitted, where you were seeking the hire and separation date for a Mr. Banish that used to work at Meyer and the performance reviews information for him.
Several
So it was unclear. Well, I'm going to do one at a time. So
together here.
So it's unclear to me that the defendant objected. And how was his hire and separation date relevant to your claim?
Because I believe he probably got fired because of what happened to me. Because it was he was right there near the equipment that fell on me.
Okay. All right.
So
So you wanted to see
non-work product, like his, like why he was released, things of that nature.
All right.
So there's multiple there.
So you didn't really respond to that. So, so do you mind his hire and separation date? As she's indicating that it could be some documentation that shows that culpability in there and that he got fired as a result of this, because somehow he might have been responsible for the display being displayed improperly.
So my only objection to that, Your Honor, would be that, employee files contain privileged and confidential proprietary information, right? And
Such as what?
so under Michigan law, employee files cannot be given out to third parties, okay? So especially disciplinary actions. I I think we would be willing to do it with a
She
protective.
says performance review information. She didn't say disciplinary action.
I think would be willing to do it with a protective order, Your Honor, because it does contain. I think there's a possibility. I haven't seen it, right, but I think there is a possibility that it could contain confidential proprietary information that Meyer had. Like what? So
I don't know.
Like his address and his name.
That's not what she's saying.
They've already given me that.
Yeah, I was gonna say you could call him as a witness if you wanted to. So you could have his name and address. So I'm not sure what the proprietary information is.
yeah, my understanding, right, is that the way that Meyer would be handling internal processes and procedures, which could include performance reviews, could certainly be confidential or proprietary to how they run their business. I have no problem producing his last hire date and discharge date, right? I don't know if we are even in possession of a performance review relating to him. So I don't have an issue producing that if it exists. We produced our answers to discovery on June 3rd, 2025. We pay for everything that is within our possession that she asked for.
Well, I don't know what it is that's different. This is a resubmitted inquiry. So to the extent that they say they're willing to give it to you, so then we're going to order them to produce that.
Yeah, but she just said his hire and fired.
She just also said she would not object to necessarily a performance review.
Yeah.
She's objecting to anything that they believe is proprietary information. And it could get down. I mean, if it's that serious, I would have to take the item, if it's there in camera, and try to look at it and see if there's anything, quote, that's proprietary or violates the law that should be redacted.
And Your Honor, maybe this would be the best way to do it is I have no problem producing those things. If I review it, realize, okay, there's some confidential proprietary information, I can file a motion for a protective order.
Okay, that's fair. Okay.
But Your Honor, I had more than just that one.
Well, ma'am, okay, can we just get to the next one?
I didn't know if you.
I got a list of things I'm showing. So can I go down my list? And if I'm missing something, then we'll let you add it.
Yes, you have.
Okay. No problem. So we have the plaintiff also claiming that the defendant's answer to interrogatory number 6 was incomplete and that the vendor for the ice blade scraper. Now, the defendant did supplement their answers on June the 20th and did provide some photos of the product, including labels, ID tags, and the name. So it was unclear what information you were seeking other than that.
Yeah, that's not a supplement. That's their original.
Right. That's what I'm saying. They gave you photos, labels, ID tags, and the name.
Yeah, but they said that the further information I was inquiring about, they said they didn't have it.
Which is what?
I have it right here. For a second, Your Honor.
Sure.
Thanks. Okay, let me just state, Your Honor, that when they did supply the documents I requested and the questions, the answers to the interrogatory, they combined them in a nonsensical way. They
What does that mean?
The defendant. They named the interrogatory document request. They named the document request interrogatories, and some of the pages go from 1, 2, 3, and then they go. And then there's a gap in the numbers. It's like somebody just threw them up in the air and put them together and said, "Hey, mix it up. We want to confuse her." So it's not.
Yeah.
If I were to go through it like at a trial, it's not in the order that it should be.
Well, I do have a note that says that we looked at the interrogatories and 5 to 10 seem to be missing. But then when we looked further, apparently they were responded to in the answers to request for production document. So something happened with how they typed it, I guess.
This is clear to me. So when I'm able to go through these at a trial, I need them to be clear and
That's fair.
concurrently.
That's fair. Perhaps maybe they could retype them in a manner that makes a little more sense. That it's
The information that she requested with regard to the ice scrapers was already produced to her. It was within our response. She just admitted on the record that she had that.
She's not talking about the ice cream.
No, we were talking about that at first because that was the next thing that you were asking for. And I was unclear. What more did you need? Because you were saying that they know who the vendor is. And I'm thinking that they gave you the information as to who the vendor was because they provided labels, ID tags, and the name.
Your Honor, she also brought an ice scraper with her to her deposition, which I questioned her about. She said it was the exact same make and model. So she's already knows what make and model the ice scraper is.
All right, okay, but we're not talking about the ice scraper right now.
Well, that's interrogatory number 6.
No, but they were saying they could not find out any information about it as far as the manufacturer, this, that, and the other. And what I said in my answer to that, in order for a vendor to even put a product on the shelf of Myers, you have to go to specifics in order for them to be able to know the logistical facts about it and the actual manufacturer. So they said they didn't know anything other than that picture, but they did know. They know the whole slew of things about that.
So what is it that in addition that you're looking for?
Well, I got that information because it's listed. All I had to do was Google it.
So then there needs to be nothing else added
That's great.
to interrogatory number 6.
Is that the script?
Yes, that's your claim that it was incomplete because they knew but you're okay with that. So there's no action need be done as to interrogatory number 6.
But
All
I
right.
think she understands that we had kind of moved past that.
Okay. Well, I'm just going in order.
No, about the interrogatories and the documents
Yeah, well,
being combined.
I don't know when we were talking about number interrogatories 5 to 10. That's what we were talking about when I went back, because apparently those answers appear to be missing. So could you all redo the answers to interrogatories 5 to 10 and label them answers to interrogatories 5 to 10 rather than they were in the request for production of documents?
We're talking about interrogatories, right, Your Honor?
5 to 10.
Okay. So number 5 is with regard to insurance. We answered that.
Okay, but where is it?
We answered it.
Is it listed? What is it listed in an answer to an interrogatory?
Yes, Your Honor.
Because I'm showing that they were in the request for documents.
I'm looking at the
They were
answers to plaintiff's first set of interrogatories, which was filed and dated June 3rd, 2025.
okay. So let's
Okay,
see.
let's go through the page.
Because my notes that I have say that you did respond, but they were inside the request for production of documents, that they didn't have their own answer.
So I'm showing that we do have our own answer, right? So number 5, there's nothing that needs to be produced.
Well, you probably didn't file those with the court, or did you?
No, they would have just been introduced.
Yes, they were, Your Honor. They put them in the M file. That's where I got them from.
It would have just been served to Miss Brown because obviously we don't want discovery stuff within.
I saw them there. They were in there actually. I printed from there.
They get served to her through there.
Well, they're there though. They are actually.
Well, I don't know if I got them.
They're in the M file. Because that's where I printed it. Because they were not sending me any copies.
Well, they might have gone to you, but they might not be filed as a court document. I don't know.
I didn't know M file separated them.
I don't know a lot about it myself. We're still learning how it works.
But if she'd like to see them, here they are. They're all convoluted and mixed up. Maybe you don't realize that they are. Maybe you didn't know. Maybe my name is Paul.
Let's see.
If Your Honor would like me to provide a copy of what I have right now, I can do that.
And she got served that, is what you're saying.
Well, that's what I provided the court. I think that's how the court knows about.
Yeah, I think that's how we know, because I think you provided something.
Yeah, and I got that. I printed that straight off of M5.
When did you give that to us?
It should be. Oh, you mean when did I?
Yeah.
Oh yeah, here. It's when I filed the actual motion. For them to discovery response. It says 7/29.
Okay, let me see.
25.
729.
Yeah. Yes, Your Honor.
You see. Okay, here, motion, limine, protective order, service. Correction to submission document request 3 and 5. Proof of service. Motion to compel, that's hers. That's in August. Okay, here is the stipulated order, which I think is your motion to compel.
But it's included in there.
Yeah, let me look. I gotta pull it up.
Oh, sorry. That's where it put.
Oh, I think I printed it out. We got it printed out right here.
If you want to see my original interrogatories and my original document request, question, I have them in the order that I gave them to the defendant in. And when they, provided them back to me, they were all mixed up.
Okay,
You know,
you can come up here. I'm gonna show you this. This says defendant's responses to plaintiff's first request for production of document.
Yep.
Okay.
Yes.
Then it goes on to talk about interrogatories. See? We object to interrogatory number 2, object to number 3. That's what I'm saying. Your responses are in the request for document.
Okay, I show
Or
them
maybe they
though.
titled it wrong. I don't know.
I don't have it titled wrong on here from what we submitted. I don't know. I am more than willing to resubmit.
That's what I was
That's
saying.
fine. Yeah, no, that's totally
This is
fine.
confusing.
I would agree with you. But I'm more than willing to resubmit because what I'm showing on my answers is correct. That it was labeled correctly. I have them in front of me here. So I don't know what happened here, but I'm more than willing to resubmit, just to be extra safe.
well, who submitted those?
Well, I don't know.
I mean,
They had to do it because there's no way. You didn't do it.
No, I'm more than willing to resubmit it. Because I'm looking at them right here and I see
Let me
that.
see what you've got.
Well, I have it on my phone. All right.
She will.
So here, take a look at that. I know. I'm sorry, my phone. So those are the interrogatories.
It's like the same question.
Right.
The only
Duplicated.
the only difference is, I can't say only because I haven't looked at the whole document on her phone, but it seems to be the title and then the introductory paragraph that talks about first request for production of documents.
I don't know, but like from that, it looks correct on my end.
I see,
But
what
I
you're
don't.
saying, what you're
You're
saying.
right. I don't want there to be any confusion though. So
That's why there is confusion. So we can fix it. She can resubmit them.
You know what, Your Honor? I really think, and this is just me, I think they intentionally did it that way. Because most of the answers.
We're not doing conspiracy theories here, Ms. Brown.
No, but this is an insurance company. Okay? And they have histories.
actually,
This is Meyer. What do you mean an insurance company?
Attorney.
Ma'am, she works for a law firm, Plunkett Cooney. They're representing Meyer. Whether she represents insurance companies on other cases is not relevant. She's not representing one here.
Your Honor, I'm sorry, but I just looked at the answers to request for admission, and the way she wrote out her actual questions, it's number 1 for the answers for the request to produce that she actually submitted. It states that she's titling stuff interrogatories in the actual
Well,
question.
here's my originals right here. Here's my originals right here.
Okay. Well, what does it say? What's your original say? Did you call things in that?
I didn't. I called them what they were. And these are. Oh, I'm so sorry.
We don't want you to trip. That's all. You're moving kind of fast.
These are not the original.
Moving with emphasis.
Because I feel good today. Okay. These are not the originals, but this is a copy of the originals in the order that they originally were. Now the original.
She has this date. It says interrogatories.
Right. They're all.
Yeah, I'm looking at her plaintiff's first request for production of documents. Okay, this is dated on May 9th, 2025. The very first question is, Please state the name, address, date of birth, driver's license number, state of issuance of any person answering these interrogatories for minor. And that's her request to produce.
But it says interrogatories on the top of this.
But the one she submitted to us says
I don't understand. I can't figure this out.
But
I'm not even going to. Because you might have titled it.
I have the
different.
original ones.
Well, she says the one she got.
I didn't.
But look at her phone. She can't be lying.
I don't want to.
She's reading from her phone.
Can I?
So,
here. I'll fold the. Okay.
so you might have titled it wrong.
Here. Plaintiff's first request to produce.
Well, that's what you wrote.
No. This is yours. See your initials right there, BB?
Okay, but I need to be able to see
You
the words.
can see it. There's
Too small, young lady. I'm 65 years old. You have to
Why?
blow it up.
I am. I don't know what to say
It's too
about
small.
that.
I can see.
I can resubmit
No.
that, but I'm gonna resubmit them in the form that she gave it to.
I didn't give them to them in that form.
Well, I don't know. I'm not involved in when people submit requests for production documents or interrogatories.
But they should be in there.
They normally don't send them to the court unless there's a problem. They send them to each
Oh,
other.
right. They put their answers to the court. And I sent mine to them.
I don't have that.
Yeah.
The only thing I have is what you sent me.
Yeah. Well, that's what I didn't do that. I didn't put that I didn't put that together.
But they,
what they
when
said.
they served you, I didn't get
Right.
it.
But
Normally, people do not serve the court
Right.
with their answers and their
right,
requests.
I don't think I did. I didn't. I just gave
So
them.
normally it would not be in this file.
Right. I gave them my request for after they served me with theirs, and I just kind of mimicked back what they did. Interrogatories and documents.
So there's a
requests.
court rule that covers all this. Did you know?
What?
There is.
That covers what?
Request for production of documents and interrogatory. It tells you, you don't have to mimic anything. It tells you exactly how to write it out,
Well,
what
but,
to expect, how long to expect your responses.
yeah, but no,
Did you know that?
No, but
Yeah.
well, oh yeah, I knew that basic part,
Okay.
but I didn't put that together. That I gave you that convoluted. It came to me like that. So what she's
saying that that's the way they received
I
it.
can't
So
do
that's why they answered it that way. I don't know. But let's just, because we're not going to ever figure out what happened here.
I may have a solution, Judge. I can send her original versions that she sent us and our answers. And then she can take a look at those.
I have it right
She
here.
can email me back but then you're saying it's too slow for you to see on the phone.
It
right?
is.
So then once it's sent to you, you can take a look,
But Your Honor,
make sure everything is in order.
I can send you my originals instead of them sending them to you. I have
She's not sending them to me. She's sending them to you.
but I already
I don't need them.
have
The court will do absolutely nothing with these answers.
the originals, but it was their response. It's all convoluted. Mine were all separate.
Okay, ma'am. Let me tell you something, Ms. Brown.
Ma'am.
It's not that I disbelieve either one of you. Obviously, something happened here that I don't know what happened, so I can't validate either side. All I know is something happened where they have a document that they say they received from you that kind of misstates the names. Then they're claiming they sent the document back, misstated because it was a response.
So if you look through that document, it's just so many things that are just mixed up. And I gave them one list of it.
The only thing I saw was it was responding to documents and it was actually interrogatories.
And then there's one page that's got cancel something and it stops and the numbers change to something else. It's just all mixed up. And then there's another page somewhere else that's duplicated from one other page.
Wow.
I'm like, wait a minute. So I had to slowly go through that to figure out what it was. And I explained it right here. Would you like me to read it? If it's a perfect explanation right here. I read it. I wrote it out. Would you like me to read it?
What?
It explains.
Explains
exactly what the convolution is. So you don't have to try to find all the.
Okay, go ahead.
Okay, it says, now here comes plaintiff M. Brown by and through self-representation. Now request the states as follows. The defendant's attorney was served on May 15, 2025 by first-class mail the plaintiff's written discovery request relative to the matter below. Plaintiff's first set of interrogatories directed at the defendant. Plaintiff's first set of requests to produce documents directed to the defendant. The defendant chose to give vague, obfuscated answers to most of the plaintiff's questions interrogatory. Defendant also gave minimal documents that the plaintiff requested, and for this reason, the plaintiff has resubmitted 5 more specific and detailed interrogatory and document requests from the plaintiff's original discovery request. After the plaintiff's closer inspection of the defendant's submissions, plaintiffs discovered the interrogatory and requests for production of documents were mislabeled. Both submissions were merged in a nonsensical way. The defendant's responses to my request for documents are titled interrogatories and have a mix of my interrogatory questions and answers and document requests and responses in the same document. The interrogatories are titled document requests. This appears to have been done to confuse the plaintiff and should be looked at as discovery abuse. Plaintiff is requesting the court compel the defendant to resubmit the document to plaintiff and have them titled and formatted correctly, along with answering the 5 resubmitted discovery inquiries and submit the documents requested in 5 days.
Okay. So the problem here is she's saying that it wasn't entirely their mix-up, that they were responding to what they received the way it was titled. I don't know. But I can, which I thought I was doing, at least try to clear up the additional 5 questions that you claimed that you asked. And that's what we were going through when we found out that this was a big mix-up with the titles. So to the extent that counsel's saying that she can resubmit this.
That'll be great, because it's all in order. It should have been just 10 questions on one, 7 on the other.
Okay, well, can we do it this way? Can we, whatever it is you believe you submitted to them with the proper title, can you give that to her? And then she can submit it back with the proper title so it's not confusing? Because right now she's saying what she got was confusing, so that's why they answered it somewhat confusing.
They got a page with 2 different.
I thought pages 5 to 10 were missing from what they submitted.
If you look at it, you can find more and more problems with it.
So can we just have you resubmit your request in with the document, whatever it is that you say you sent? She says she didn't have that one. Can you just resubmit it?
Sit those back in May.
Do you have it still?
I mean, I probably have to dig it out. I submitted them.
Well, if you want answers that look like they're properly titled, can you just resubmit what you sent?
Well, this is it right here. This is the exact question.
Okay, and if that's the way you submitted it?
Exactly the way. It's just that I had done it over, and it doesn't have the title and everything on it. And these are the exact questions. The exact answer.
Okay, but why don't you send it in the proper form with the
just for me?
Okay. Ma'am, okay, I get it. That's yours. Can you resubmit it in the proper form?
I did, Your Honor. I don't appreciate, and I'm no offense, but lawyers are tactical at this. I did not send a document that was a misconstrued.
Okay, well, I don't know how she has that.
I didn't do it. It was very
okay. In a minute, am going to want to go home, and I'm sure you will too, and so will counsel. So we got to stop going around and around and just get something done here, which means submit it again so she can respond to it in the way that you want it responded to, where it makes sense, where you could use it at trial if you need to use it. So those, okay. Ma'am, you got to send it to her though.
I will.
So we were going through resubmitted number 5. I said they would produce that. That's the separation and hire date and the actual performance review for Mr. Banish. And if she believes that something needs to be protected, she'll file a protective order on that. Okay, that was interrogatory and resubmitted number 5. For resubmitted number 6, no action need be taken because she says she's clear on that as to who the vendor is now. So you don't have to do anything. The next was interrogatory number 7, where it was a video requested of the actual incident. And the request state whose custody the incident report, video, still photos 3 hours before and after 8:30 a.m. on the date in question is.
Where are you reading?
I'm reading from number 7, where you say that they did not give you that, or it's incomplete.
The resubmitted question?
I'm reading what I believe. I'm reading.
That they gave me the answers to the question.
I'm reading the ones that I thought were in dispute.
No, these are the ones right here. Can you look and see if you have the?
Ma'am, I'm reading from my notes. So.
Hey, these here they are. I don't have what you're reading.
Okay. So if that's not an issue, that's number 7.
Hear what you say?
The video of the incident's not an issue, then fine.
Read what you have, please. I don't have that. You must be reading from.
You claim that the answer to interrogatory number 7, that no video of the incident is available, is incomplete. Because they said no video was available. You said it was incomplete, and that you requested video surveillance and you want video of you entering Meyer.
Yeah.
That's not an issue.
That is an issue.
So why are you telling me when I'm reading this that it's not an issue? You're complicating my job. Trying to go through these and you're telling me no, and it is what you're looking for. Okay? So, and your request stated that you wanted to know who had custody of the video incident report and still photos for 3 hours before and after 8:30 a.m. And you wanted that.
Yeah, because they were saying there was no video of the air.
So what are you looking for? The entire store video?
Surveillance of me in the store.
So that's not every video in the store. You're looking for a particular camera?
Just surveillance of myself coming in the store, going
Okay.
through the store.
Are you objecting to providing surveillance of her coming in the store?
Possession of it, Your Honor. This incident happened back in 2022. She filed this lawsuit in 2025. I believe Meyer video was only retained at most 90 days, at most.
Yeah, but the gentleman, the manager, said he didn't have video on the date of the incident.
He probably does. What do you mean? The date of the incident?
And
When it actually happened?
Yeah, he generated
3 years ago. He said he didn't have it then.
He said the area. So in other words, he was covering up.
Okay, but ma'am, we can't. I don't know what he was doing. You can ask him that at trial about it. All I can do is do your request. And if they no longer have it, if they had it, and these
destroyed it or just.
Well, ma'am, you have to request and preserve those things because
it was requested by my attorney.
Okay, well, I don't know. All I'm saying is most businesses they don't keep these things forever. In some instances these recorders just loop over it again.
Yeah, the request was made right away by my attorney.
Well, ma'am, I can't do anything about a video that's 3 years later that's no longer in existence.
But they were saying that they don't have a video, but yet still, even if there's a video.
What would you like me to do?
Well, I understand, but what I'm saying is I believe they intentionally.
Okay. I don't know that. But you can certainly question them about that. What was their motive? Why isn't it there? Didn't you receive a request? You can do all that at trial. I can't order something that doesn't exist. So as far as number 7.
I don't even see where you're getting 7 from. I don't know why I don't see my 7. I see 6. I just don't see 7.
Okay. Ma'am, I'm looking right here. Just so you don't know what you're doing. This is attached to your, ma'am, it's attached here, exhibit number 3.
Can I approach?
It's
See it, Your
because this looks appear to be yours. So what are you approaching me for? I see it.
Oh, I did.
I don't need to see
it.
Okay.
Okay, I see it.
So no action need to be taken on that issue because it doesn't exist. Then you object to defendant's response to request for production of document number 2, which says that's not possession of documents responsive to the request. And you say you want photographs, films, videos, and an attempt to recreate the incident, giving rise to the action or to demonstrate any scientific principle. They allegedly state in court filings that it would have an accident recreation expert testify. And you seek documents experts relying on. Well, do you have an accident reconstruction person? Because
We have not retained one, Your Honor, and if we had retained one, we would have provided the expert report to Ms. Brown.
okay, so
Well, they made a statement as if they were going
okay,
to definitely.
but so then the answer to that is no accident expert is retained and no report exists.
Correct.
So answer that way, because I don't know what you said.
I think the request was using, Your Honor, and we were responding that we didn't have anything responsive to the request.
Okay. Well, now you can say you don't, just what I said. That you don't have anything because you don't have an accident expert.
But I don't see why the request could have been confusing. I just repeated what they said exactly.
Well, this is the answer.
Okay.
No document because no accident expert. If that changes, they will be required to supplement and put that down. Defendant required to supplement if that changes.
Okay, now the next one.
Okay. Production of document number 5. Any and all things which you will or may offer as evidence at the time of trial. Okay, well, you're in the duty to supplement that. You said you didn't know.
They haven't offered any. They had me offer and put forth everything I had, every piece of evidence, every bit of information that I had
Okay.
pertaining to pursuing this claim. They have not provided me anything about any exhibits or anything.
Do we have a trial date set yet? Okay. Well, you need to prepare that answer. Because normally it's in our did you get a pretrial order?
Yes, we did, because I copied it.
You usually ask for exhibits there.
We did file an exhibit list, Your Honor. This one, I don't think we really even have any exhibits necessarily to present. So it says it was non-responsive. I mean, I can.
Well, the answer, defendant said that it doesn't know, but it will supplement its answer if it has when it determines. And you need to do that probably, I'd say at least 3-4 weeks prior to trial, so she can have time to look at it.
Yes.
Make a note, supplement 4 weeks prior to trial. Okay, then she added her request that seeks emails, letters that are relevant to the case, facts, or pertain to the defendant's knowledge of the incident. Well, that's fair.
It's supposed to say non-work product. I had another supplement I did right after when I.
What do you mean non-work product?
Well,
What does
they
that
trying
mean?
to say work product means,
Attorney-client product?
right.
Well, no. You're not entitled to that anyway.
No, but I want.
You're talking about from Meyer, that things that they might have said back and forth just between themselves and not anything they said to their
Right.
lawyers.
Pertaining to, right, you can please.
And emails between HR management and Mr. Banish. And documents presenting at trial. We already have that. We're going to do that. And communications involving Mr. Tim Dennell, the store manager, regarding the incident. All of that's relevant.
Sure, but if we didn't produce it, we don't have it.
So did you respond that you don't have it?
I think that there has been confusion on what the answers actually were, and that's why I'm willing to resubmit them, because I don't know what you have in front of you.
What I have is this document here that she submitted with all of her renewed
Yeah.
requests. And to me, those are valid.
Which number are we on right now?
Well, it is some new information that she has sought when she was talking about
The resubmissions.
document request number 5.
Request for days.
Yes. And she wants now the emails and letters relevant to the case that pertain to defendant's knowledge of the incident, emails between HR management and Mr. Banish regarding the incident, documents that you want to present at trial, and communications involving the store manager regarding the incident, as long as it's not work product.
I don't even have those requests. So I don't know. I don't even have.
She says she submitted it through M5.
The ones that we responded to are the ones that we received. I don't even see.
Could you send those?
Your Honor, this
Ma'am,
is
listen. I just directed her how to answer those. Can you send them to her again?
Your Honor, this was the motion that I filed. It was a hearing form, and I called. You do them again.
If you want the answers, you'll send them over to her. She says she doesn't have them.
But I found them for infile, and they said they submitted them to the attorney.
What do you want me to do about that, ma'am?
The infile.
Nobody is saying that you didn't do it. She's saying she just doesn't have it.
It's an infile.
Okay, so you want to get answers that she says she doesn't have, and if she goes to infile and they're not there, she's not going to answer them because she doesn't have them. You could make life simpler by just giving her the 2 or 3 sheets of paper you got there so she can supplement the answers.
It was
Instead of arguing with me about it, whether it's in infile or not.
I thought that when I submitted a request for a stipulated order compelling discovery,
I have that.
this is all one thing.
Did you see it?
Those no.
It's attached to her motion, which she calls a stipulated order.
That's fine, Your Honor. We're not required to respond to that. We're not required to respond to those discovery requests. We responded to the discovery request that she sent us during the discovery period.
All right. And so now she has said you have them. So I'm telling you to respond to those.
And I have no problem with that, Your Honor.
Okay. And it's attached to her stipulated order compelling defendant to produce discovery responses, which should be a motion to compel discovery. And you called it a stipulated order. It's not a stipulated order. And that was filed July 29th. Okay. So I'm just going to recap what we got here. Just what?
It was a little bit more under that one. I think I wanted something about Tim. Then
I said all of that's granted, ma'am.
Thank you so much.
Okay. So this is what I'm going to ask counsel. Prepare an order, please, for this. So as far as her motion in limine is concerned, that's denied. The motion for ex parte protective order to limit discovery, that's denied. Because I am granting your request to compel signed authorizations for these documents here.
We limit the date on Social Security.
Medical records, Department of Treasury, Walgreens, Social Security, and Dr. Woolston. That's the ruling of the court. If you don't like it, I'm sorry, ma'am. I'm tired of going through this at this point. We're going through the same thing over and over, and it is 4:40. I have been very patient, and I'm starting to wane, and I don't want to wane. Okay?
Yeah.
All right. Now, as far as her request on this stipulated order, which is her motion to compel your discovery request, those are the additional ones that you're going to be responding to that are attached to that July 29th submission. You will respond to, you said the original ones you're going to redo.
I'll send them to her again.
She's going to send those just so it's clear And we're not talking about documents, we're talking about interrogatories. But these new ones are attached to the July 29th, and they're just a few. So the first one deals with her request number 5 to produce, and we're going to grant that, which is the separation and hire date for Mr. Banish and a performance review information subject to any protective order that you might choose to file a motion on. If you look at it and think there's some kind of protected information in that. As to number 6, no action need be taken. That is to the, and you're going to say this in your order. That's to whether or not you have given them the information as to the ice blade scraper vendor. Defendant need not take any action as the plaintiff has that information. As to number 7, defendant need not take any action. That is to the video of the incident, as there is no video available at this point in time related to surveillance and the defendant coming in and out of the store. So you can say that nothing action need to be taken because the video does not exist. As to request for production, number 2, which deals with documents not in possession of the defendant, which she said were not responsive. Your response is going to be that there are no documents because you don't have an accident expert that's going to be testified. So there's no other photographs, films, videotapes giving rise to any demonstrating any scientific principles, and that there's no expert report or an expert. So therefore, no action need be taken, but it needs to be supplemented if you do intend to hire an expert. As to request for production number 5, you will produce this at least 4 weeks prior to trial, and that has to deal with any evidence that you may offer, documentary evidence that may be offered at trial. And also the other things that she asked, inclusive of that, would be emails and letters relating to the defendant's knowledge of the incident, emails and communications between HR, upper management, and Mr. Banish regarding the incident. Whatever you're going to file as exhibit lists, those documents, and communications involving store director Tim Dennell regarding the incident, as long as it's not work product with counsel. Those are all going to be turned over. So that's granted.
And that's all from the stipulated.
From that stipulated order, these are attached to. Okay, so you can prepare the orders for all of those for me and send them in. And we're not doing, obviously, the summary disposition of today. So call my clerk and get a date for that. And we can have that heard since she has already seen it. There shouldn't be any major delay on it. Where's the clerk? She back there? It's going to be after whatever summary disposition date you got.
Did bench trial or jury trial?
Oh,
I know, sorry.
And you're doing a motion for summary?
They
they did it. They're going to need a hearing date.
yeah, if you can give me one now, that'd be great.
Yeah.
That Florian note to order your box of pants.
Low.
Of course.
What about these red ones?
Yeah.
Oh,
Sorry.
wait.
Go right away.
Well, in my black cabinet that's next to my
First
phone.
day, October 30th at
Oh.
1:45.
I got a couple of 3, 4 appointments in October. I don't have my schedule with me. They're medical related. I have,
That's a motion hearing date?
yeah. I have to check my schedule. I'm sorry. I did. Matter of fact, I can check wrong. Let's see.
October 30th works for me.
If I can remember my password, I could see right now when the date started. I can't remember my password to my portal at the University of Michigan. I got all my list of all the days. I might have a bunch of days in October that I have to go and do a bunch of stuff. How about what's the day? Tuesday? How about can I call you first thing in the morning and let you know what my schedule looks like? What date is that?
October 30th.
Okay, hopefully it won't be on that day, but I'll call you first thing. What's a good time?
Probably about 9 o'clock.
Yeah, and let you know that if 30 it's clear. Okay.
That'll work.
And my apologies because I should have brought that list.
Will you issue an order with like the date and time? No.
You gotta wait.
Once she confirms.
When she confirms what I'm saying.
I can just call your office.
Okay, that would be great.
Yeah.
Thank you. That's,
Thank you so much, everybody.
Okay, and then we'll go from there for the trial date after the motion hearing, Judge.
Yes.
Are we setting a trial date right now or are we waiting until the?
You're gonna tell us when the motion, because, you know, the motion's not till the end of October. Trial date might not be till December. And we're short December, so it could be early January at that point. We don't know.
Ms. Brown, do you have my email address?
Is it on your card?
Yes.
Well, but could you give me a secondary card? Sure. Just in case we can't.
Yeah, that way, if there's any issues with the discovery, you can get those with me.
Thank you. Thank you. Sorry for raising my voice. I mean,
That's okay. I understand.
I totally understand. I just get it. Passionate, you know.
They just hear and see you on the camera, so they get a little nervous.
With it, they get nervous.
Yeah, they don't want you doing nothing to our judge.
I guess I'm immune to it.
All right. So in this quality, sir, your name?
Clayton?
Clayton. So is it Clayton Grant?
Yeah.
Okay. And your middle name's Isaac? Or no, Anthony?
Yeah.
All right. What's your date of birth?
9/1/1978.
Okay. So let me turn to Ms. Kamari from Pacific Point Defense.
Oh,
Your Honor, I've gone over his rights and he has no questions. We're stipulating to probable cause for purposes of today's hearing only and asking the court to enter a plea of not guilty. Mr. Grant is requesting court-appointed counsel. He currently only receives about $1,200 a month.
Right. So, Mr. Grant, you're charged with this allegation of possessing a controlled substance unlawfully, and I'm going to enter a plea of not guilty to that. I'm appointing an attorney to represent you, and that'll be Pacific Point Defense, Ms. Kamari's office. And then I'm going to set another court date, and we'll talk about possible conditions on your behavior until you resolve the matter. But first, I'm going to hear from the prosecutor, and then I'm going to hear from Ms. Kamari on your behalf. So, Mr. Sharp.
Thank you, Your Honor. City has no objection to a PR release. The city asks for law-abiding behavior, that he did not possess or consume any alcohol, marijuana, or non-prescribed drugs.
Okay. And Ms. Kamari?
Your Honor, no objection to those conditions.
Okay. So you'll be released, Mr. Grant, but I'm going to give you a court date. You got to come back.
okay.
You don't have a mailing address of any kind, or do you?
I'll find a post office. I'm gonna set up here for a while. I've been getting out of Oregon for a while. It didn't take until it did, and I was here in Washington for a couple of days, so I'm gonna be here in Washington. So I'll go to the post office to get a, you know, one of the-
Okay. Right now, I'll just hand you a notice. Do you have a phone we could send you a text message reminder to?
No, you can call my dad though. He's the way I can get in touch with him. I get a couple bucks from him. If I don't get that, I'll absolutely help. I need to get
Okay. Well,
That's
we'll
what
just
I'm
hand you
doing, man.
notice.
Huh?
We're going to we're gonna hand you a notice for your next court date. You'll have it in hand. So what are we looking at? So October 28th, 8:30 in the morning, you're gonna be back in court, October 28th at 8:30. I'm writing it down for you. Got an attorney, they'll be there too. And your job,
Yeah, I'm not worried.
violate,
Fine.
Yeah.
I know what I'm doing with that.
violate the law, right? Okay, and, did you have you had a question or something?
Yeah, I just
Something
want
to say?
what's the date today?
Today is September 23rd. You'll be
Okay,
back October 28th.
cool. That's fine. I'll be there.
Good. All right. We will see you then.
All right, thank you.
Thanks. That's all for today. You can knock on the door.
Here you go, right? I got free.
You can go. You can go.
See you here.
Is that Ms. Hodges? Need to get you unmuted. I don't know who's going to do that for you, but we can't hear you. We need to get you unmuted.
Can you hear me now, Your Honor?
No, not you in Nisqually. I'm sorry, Ms. Hodges in Thurston County Corrections Facility. We need somebody there to unmute, but we'll jump to you in Nisqually while we got you. Your name?
Amos.
Mr. Amos. All right. Several matters here. Okay. All right, Mr. Amos, you're here. It looks like maybe yesterday we tried to have an arraignment, but today we're going to do it. And we got a couple of things for arraignment. A criminal trespass in the second degree alleged from August 21st, and a criminal trespass in the second degree and obstructing law enforcement from September 21st. I'm going to turn to Ms. Kamari here. And you're muted, Ms. Kamari.
Thank you, Your Honor. I've gone over his rights and he has no questions. We're stipulating to probable cause for purposes of today's hearing only and asking the court to enter a plea of not guilty. He is requesting court-appointed counsel as he currently is not working. Pacific Point Defense represents him on other matters.
Okay, and those other matters are for the court today. So, Mr. Amos, then, as to those two allegations from August 21st and September 21st, I'll enter pleas of not guilty. I'll appoint Pacific Point Defense to those matters as well. You can be appointed on those probation violations, the cases you pled to in June. And there's another case pending trial still, a theft alleged from March 1st. They're your attorney there. So we're going to have another court date here. And I'm going to hear from the prosecutor, and then I'm going to hear from Ms. Kamari on your behalf about release conditions. And then we'll set that court date. So, Mr. Sharp.
Thank you, Your Honor. City's asking for $500 bail on the newest case. Well, actually, on all of the cases. Moving to revoke probation on the 3 probation cases based on the new law violation, and then moving to revoke release on the other pretrial case. For conditions, we're asking for law-abiding behavior on the new one. No contact with taco time. That request is based on concerns of Mr. Amos's likelihood to reappear. So he believes some bail is necessary, and $500 on each case is not excessive. Mr. Amos, Lacey had not known the name Nolan Amos until about April of this year, and now he's got 6 cases. He's had a warrant issue in Lacey in the past. He has an active warrant in Olympia in the case from April of this year. Obstruction charge in this case arises from Mr. Amos fleeing from officer to detain him to investigate the trespass charge. Now, granted, it wasn't a high speed attempt to flee, but he did leave the scene despite officers' directions for him to stop so that they could conduct that investigation. And I think it also is important to note that, in this short amount of time, officer noted in his report that they're familiar with Mr. Amos and identified him by sight. And that speaks to one of the cases we have here this year. speaks to his willingness to follow court's orders, including an order of court dates.
So there are two matters, the August 21st one and the September 21st, which is.
So the August 21st was a Safeway, Your Honor. And then the September 21st.
Right. Okay, Ms. Kamari?
Your Honor, we are asking for release on personal recognizance. The most recent allegation was, standing under, outside of the location from the rain, in a way, as alleged for the obstruction. Mr. Amos, as my office does represent him, and I have a good contact number for him. And he's currently not working, but he's in the process of getting a job. And so we're asking that he be released on his personal recognizance.
And I see Superior Court's got some court dates coming up, October. And he's released on those, I would anticipate.
Also, Your Honor, that morning I was going to take care of my warning.
You might want to not say anything about what happened that day. Your attorney would rather you talk to them about that. Okay, good. Court in Superior Court, probably because of this. All right. So, Mr. Amos, I am going to have you post 500 cash or bond on each one of these, and that's 2,500 cash or bond total to ensure that you come back, to ensure that you don't violate the law. We've exactly March and April, May, August. You're just kind of become too known a quantity for thieving and obstructing and harassment. Yeah. So 500 cash or bond to be released. And then, of course, don't violate the law. Don't go back to the Safeway. Don't go back to taco time. And come back to, rather than us having to issue warrants. So we have, I think.
Your Honor, may we set a hearing for this Friday then if bail's going to be impaired?
So Friday, directly the 1:30 calendar?
Yes, please.
We can do that. I will do that. And we'll see where we are and give you a chance to talk to your attorney in the meantime, Mr. Amos. Yep.
I'm not going to be able to post. I just don't
If
have.
you're not able to post, then we'll see you at 1:30 on Friday. If you're able to post, then you bring yourself to court at 1:30 on Friday.
If I may finish, Your Honor, I was already having my second interview at Denny's. Like that,
Yeah.
That day.
And I'm sorry that you're doing that, but we have had a constant now 6 months of you and taking people's property, harassing people that you've been convicted of. No. If you postpone, so be it. If not, you're back no matter what. Either way, Friday at 1:30 with the City of Lacey. Did they take care of this county case? Why is it? I know, but did they take care of it? You said no. Okay, I'll take care of that then. All right, so that's it for today. I'm going to write all this up, and then you'll be talking with your attorneys this week. It sounds like. Sure.
Might be worth making sure we've got all.
Do we have more? I have 4 Lacey cases on here today. Is there something
Yeah, let me see
missing?
something.
Let's get them all set then on that day. You could send those over. But they have a pretrial 1010. Okay. Just leave all those set. Don't touch the county case. We'll just
Here on the one. Let me see. 5A013.
1 second. She's opening up.
5A013 4904. 04. That's post disposition. city's motion to revoke clause one.
So, Mr. Amos, you can knock on the door and they'll let you out, and you'll talk to your attorney. Wait.
Weird to all I can hear is somebody in one of these rooms. And it's always showing up. And I hear her like sniveling and not him, girl.
They're asking about judge.
Like, I know. Is he doing different sentences? We're going to take her.
No, you're.
We're going to talk to Hodgees right now. So, Ms. Hodges in Thurston County Corrections Facility.
Yes.
All right, Ms. Hodges. The attorneys here should know that I was in Olympia Municipal Court yesterday watching a hearing with Ms. Hodges. And then today I read the report under 25 DV 929 that was to be heard in the other courtroom, which has probable cause for, on their previous hearing, of a violation again of a no contact order with Corey Solomon happening at about 9:30 last night. So here we are again. I understood yesterday at the City of Olympia that she had recently gotten out of treatment and they set that over and allowed her release. But now I'm wondering. So here we are today.
That sounds
I
like
don't
you
need it. I
already
already read
reviewed
it.
that.
Yeah. So we've got several matters pending trial, and then we have a post-conviction matter. So what are we doing today?
Well, Your Honor, I spoke with Mr. Pilon. I've spoken with him a couple of times. He was in court this morning, not aware that Ms. Hodges had been arrested on new charge, and he's unavailable this afternoon. She failed to appear back in June. This case has been referred to mental health court, or these cases, but it's just been jammed up since then. Again, I've spoken with Mr. Pilon about this. We're trying to work through these cases and negotiate, but it's hard to do that when she's not staying in touch with her attorney. Best he's been able to do is get a hold of her mother, trying to get in touch with her. And feeling this to the court just got out of frustration here because we are looking at a mental health court likely. But with this new probable cause that the court was able to review, and her not appearing since June 20 or since before June, seemingly substantial bail is necessary now. We're asking for $5,000 on each. We'd be open to reviewing that, if Mr. Pilon is able to appear and has a basis to modify that. But for today, that's what we're asking.
So I have him on 2 cases and Pacific Point Defense on 3, and we've been trying to figure out if we're just going to keep the attorneys as appointed, see if Mr. Pilon's going to come in on other ones or not. But Mr. Swenson?
Your Honor, my request today was going to be to leave Ms. Hodges released in her Lacey matters and to address this at a later time when Mr. Pilon could be present. I'm not sure what happened. Does anybody know if she was seen in courtroom 2 already?
In courtroom 2 yet?
Yes, I think, yeah.
Okay, Sergeant Meyer. All right, so this is what I'm going to do. We're going to get this set. I'm going to hold you without the opportunity to post bond now on the post-conviction matter on the 4A 466676. Given what I've read at the prelim under 25 DV 929, you're in violation of this court's order yet again.
Can I say something though?
We're going to hold you then, and I'm going to set a court date here for everyone to be present. I'm going to set October 7th, directly the 1:30 calendar. We're going to get a hold of Mr. Pilon and let him know that. And Mr. Swenson, your office represents on 3 of these cases, maybe between the 2 of you. If that's the change, let us know if Mr. Pilon's going to take over on all or not. That's fine.
Sorry to interrupt, but
Oh,
it seems like your hire already.
I completed my mental health assessment yesterday.
Yeah, it says that
Yesterday.
they may have set bail on the Lacey cases already this afternoon. I just got a note from Mr. Fortunato across the hall. Says that they're the total 50,000 including
There
the
you go.
Lacey case numbers. I'm sorry for that messiness.
On the 4A4666 matter too? If you could get a
That is included in
judgment
the
and
list here.
sentence from them, can they?
I just got the mental health assessment yesterday to get into mental health court.
Well, I don't, we'll hold off on that until I see those orders. And, but that's my intention, unless if Meyer's already done it. So do we have a court date set there? I'm going to set October 7th at 1:30.
So the court.
You have the judgment and sentence?
I don't. But I
Here it
have
All right.
shot this not out.
Well, tomorrow? County case. So I'm going to set the city of Lacey for October 7th. And if things need to be done earlier, let us know, Mr. Swenson, and you'll be in touch with Mr. Pilon and we'll set directly to 1:30. But on the 4A matter, I'm holding without the opportunity to postpone. And that's it for today, Ms. Hodges. We'll see you soon. So let's find out from courtroom 2 what they did on those other cause numbers. And if they've already done something, I won't. If they haven't, then I will.
They run over the
podcast. Well, I need you now. So
Yeah.
okay, let's see. Linda Roberts, is it? Angela Wales?
Yeah.
Okay, Angela Wales is. And your middle name is Marie?
Yes.
Okay, what's your date of birth?
November 17th, 1981.
Okay, so you're here about a warrant we issued back in August, and I'm going to turn to the city here, Mr. Sharp.
Apologize, Your Honor, I didn't catch your name.
Ms. Wales.
Miss Wales. I believe Your Honor should have a warrant upstairs.
Wales? Thanks. All right, so Ms. Wales, looks like you want to plead guilty to criminal trespass in the first degree going back to June 27th. Is that right?
Yes.
Okay. Feel you had enough time to talk to an attorney about making this decision to plead guilty?
Yes.
Okay. And in this plea are all of your rights to have a trial. Do you understand those rights?
Yes.
Do you know you're giving up those rights to have a trial in this case if you plead guilty?
Yes.
Okay, and that's your choice?
Yes.
All right. So I see there's a recommendation here from the lawyers as to how I should sentence you. Do you understand what that recommendation is?
Yes.
And do you know I don't have to go along with it?
Yeah.
Okay, and maximum possible sentence to this crime is 364 days in jail and a $5,000 fine, and you're aware of that?
Yeah.
Okay, so I've asked you to make a written statement here as to what you've done wrong that makes you guilty, and you're saying that back on June 27th of this year, you were in the city of Lacey, you unlawfully entered Target after you'd been trespassed from that property. Do you accept that as what you did wrong?
Yes.
All right. Now, has anyone threatened you with harm or made you any promises that have caused you to plead guilty?
No.
Well, how then do you plead to one count of criminal trespass in the first degree?
Guilty.
Okay. I'll accept your plea, Ms. Wales, and I'm doing that finding you know what you're doing. You're doing this voluntarily and intelligently, I see, and you're doing this understanding the consequences of pleading guilty, and that statement supports this. So we'll move on to sentencing. I'm going to hear from the prosecutor and hear from Mr. Swenson on your behalf, and then I'll turn to you if there's anything more you want to say, all right? Okay. Mr. Sure?
Thank you, Your Honor. We just asked the court to adopt the recommendations.
All right, Mr. Swenson?
This is an agreed recommendation, Your Honor. I'd ask the court to follow it and to waive any legal financial obligations. Ms. Wales is statutorily indigent, does not have the ability to pay. Your Honor.
Okay. Well, anything to add to all this, Ms. Wales?
No.
Okay. So you know now, don't go back to the Target in Lacey?
Yes.
That means their parking lot, any part of the Target, okay? Inside, outside. All right. I'll go along with this. You've served 4 days, I understand, in total, and that's the punishment. And then you'll be released, and there'll be like 360 days not imposed for the next 2 years, and you just stay out of the target and you stay out of trouble. All right.
Okay.
Okay, it's a deal. All right. Any questions?
No, ma'am.
Okay, then that's it for today, and they'll get you out.
Thank you.
You're welcome.
Ms. Myers, who's seated next to you up there?
I'm with Miss Monica Hodges.
Looks like she's got a couple of backups, just DWLS in the thirds, confirmation on the Sep 24th. Then it looks like there's a new domestic violence related offense. So was a preliminary appearance on a domestic violence related offense. Mr. Fortunato, what's the state seeking probable cause for?
Your Honor, the state is seeking probable cause for 1 count of violation of a domestic violence no contact order.
What's your position on probable cause, Ms. Myers?
Your Honor, will stipulate to probable cause for the purposes of today's hearing only.
And it looks like you have some pending violation of a no contact orders in Lacey also. Are those set for hearing right now?
Tomorrow.
Tomorrow? Okay. So did you discuss with her legal rights?
I did, Your Honor, and we would waive any formal reading. At this point, we'd be asking that Thurston County Public Defense be appointed as a recipient of TANF, so she is statutorily eligible.
I'll appoint Thurston County Public Defense to represent you. I'm filing. Did you say you were stipulating to violation of a no contact order?
Yeah, for the purposes of
probable cause. Probable cause. I'll find probable cause on that basis. We're going to set conditions of release. I'm going to hear from Mr. Fortunato, and then I'll hear from Ms. Myers. And if I haven't already said so, I will appoint Thurston County Public Defense to represent you. Unless I hear differently, Mr. Fortunato, with regard to the DWLS and the thirds, I would just incline to leave those court dates set. But then I'll hear from you on conditions of, unless you disagree with that. They seem to be unrelated to this sort of activity, but I will hear from you on conditions of release on the new charge.
That's totally fine as to the DWLS 3s, Your Honor. I would at this time make an oral motion to revoke on the basis of the new law violation, specifically with regard to the 24 DV 0805 TCP cause number. That's another case out of this court for violation of a protection order with the same victim.
Is that a court? That's not on the calendar, I don't think, unless I missed it.
It may not have been set for the calendar. There should have been a motion to revoke. If it hasn't already been filed, then it will be.
Oh, I see. I was looking at the wrong one. Yeah, it is actually. No, I'm sorry. It is, and it's set for the DWLS third is the one where I was looking at the wrong one. Sorry. Yeah, it has a court. It looks like it has confirmation on September 24th.
That's what I'm saying.
Okay, sorry for interrupting.
No
Continue
problem. Your Honor, I'm asking for $100,000, 50 between both cause numbers. I'm asking for no criminal law violations, no firearms or dangerous weapons. Abide by all the active no contact orders. There should be one out of this court for the city of Lacey. There should also be one out of Superior Court. I'm also asking for pretrial services supervision, understanding that she's now supervised by Thurston County District Court for both her city of Lacey and her county matters, also city of Olympia, and also Thurston County Superior Court. I'm asking for that bail amount on the basis that Ms. Hodges is now before the court on her 5th allegation of violation of the protection order, the same protection order in a little over a year. As I'd stated, one of the cases is out of Ole, one is out of Lacey, one is out of Thurston County District Court, and one is a felony assault in violation of a no contact order out of Superior Court. This is her 7th active DV case. in a little over a year and a half. This order springs from a July 2024 assault 4 from Lacey that's still predisposition. Ms. Hodges, from the state's perspective, clearly demonstrates a danger of interfering with the reporting of administration of justice through violations of this court's orders. In this incident, she was also picked up on an Olympia Muni warrant for failure to appear that had been out since July. Worth noting that on August 12th, 2024, at her preliminary appearance for the 24 DV cause number, this court imposed $10,000 cash or bond to ensure future compliance with court's orders. Given warrant history, likelihood of interfering with the administration of justice, and a community safety risk via violation of court orders for protection, state believes that the bail amount is appropriate.
And so is she out on, is that the one ending in 805? She's posted $10,000 on that?
It appears so, Your Honor.
Ms. Myers?
Your Honor, we would object to bail in the amount of $100,000. When we're dealing with clients who need the assistance of public defense, asking for a bail in that amount is nothing but grandeur and just aesthetics to say that it's $100,000. When a client is indigent, any bail will cause them to stay in custody. Additionally,
She posted 10,000, didn't she?
the help of other individuals and also bail bonds. At this point in time,
And so, hang on just a second. And so bail was set, she posted that, and she's on a probable cause basis, she still can't comply with these no contact orders.
And Your Honor, the issue we find ourselves in is the day that this happened, she relapsed. So prior to this, she was an inpatient for 28 days. She got out. She got out wanting to do a longer stay in inpatient and relapse. And she found herself back in a comfortable space for somebody who was in the position that she was prior to doing inpatient. And this happened. Allegedly, she finds herself in a very tough situation. And at this point, her biggest concern is getting back into inpatient. She is doing mental health court for all of her Lacey cases. And I believe the Thurston County ones are grouped into that. She has 2 children that she's responsible for taking care of. She did a mental health evaluation just yesterday, right before she got picked up, as well as the intake at BHR for intensive outpatient. But even while she was at intensive outpatient, she was asking to go back into inpatient. The issue is addiction at this point, and she cannot get the help that she needs unless she can get out of custody. And at this point, $100,000 is tantamount to a no bail. I don't believe that there's any client who walks through the doors of public defense who would be able to pay any percentage of $100,000. We understand if there is bail imposed in this case. We're not asking for her to be PR'd. At this point, though, with the other amount that she's already had to pay on these cases, the only thing that would be likely for her to be able to post would be $500. And like I said, we understand. We see the other bail amount that she posted. However, that alone took a good chunk of money out of her wallet. At this point,
Everything's okay.
She understands that she needs the mental health help. She understands that she needs the addiction help.
Give me a moment, please. Did you say she's on the calendar for Lacey tomorrow?
The CO's just advised me she's on today.
I had heard that from Matt Sharp as well, Your Honor.
On the in custody calendar, or in? Okay, so
I believe
she'll be seen there.
calendar. Yes, Your
So
Honor.
they'll probably be asking for the.
They're accepting
Wait, hang on just a minute. Oh, I see. So she's on the calendar for tomorrow. 9/24. She's on yes, he's on the calendar tomorrow on the domestic violence related calendar for confirmation. So who's her attorney? Was Eric Pilon still her attorney?
It was Eric Pilon, yes.
Is he still?
I believe so as of this morning. I don't know if he's filed any motions to withdraw.
So, you were talking earlier about public defense. Is she asking to have someone appointed on the new charge? Because she's not the public defense client on these other cases.
She cannot afford Eric Pilon anymore. At one point, she did retain him, but she's unable to pay.
Well, he's still listed as the attorney as record. I'll appoint him on the new charge. And I'll appoint Thurston County Public Defense, my mistake, on the new charge. I'm not going to adjust conditions on the DWLS in the third. I will set it on the for trial confirmation. I'll set it right on the 1:30 calendar now for tomorrow at 1:30. On the two violations of no contact order charges, the most recent one will be set for arraignment. We'll go ahead and supposed to be set within 3 days these days. Let's go ahead and set that on for tomorrow. We'll convert the and again, we'll leave that for trial confirmation and the other case on tomorrow, which is a short notice for your office. And I don't know whether Mr. Pilon will be there or not. We're going to set all these on the 1:30 calendar. With regard to bail, I am going to set bail in the amount of $25,000 in each case. And that'll be on for 1:30 tomorrow. And it's primarily the basis for the bail is the inability to follow court orders. It's, believe it or not, it's almost like I'm trying to save you from yourself. I mean, you just can't, with these multiple violations, that's just where we're at. With regard to the treatment provision, the inpatient treatment referenced by Ms. Myers, I don't agree with Ms. Myers and say, well, you can't get the help without if you're in custody. I don't agree with that. We do furloughs all the time. They're not uncommon to do furloughs to send people to inpatient treatment. And if your attorney, whether it's Mr. Pilon or someone from Thurston County Public Defense, gets that in place, you can bring that back before the court on a moment's notice, and it'll probably be agreed to do a furlough to get to inpatient treatment. So, again, on the new charge, bail is going to be set in the amount of $25,000, cash or bond. Conditions are don't have any criminal law violations, don't possess a firearm or other deadly weapon, comply with any existing no contact order. We're just going to, and again, I know this is short turnaround, but we're going to put this on tomorrow on the in custody calendar at 1:30. Mr. Pilon still listed as attorney of record. Mr. Fortunato, would be helpful maybe for you to reach out to him and just let him know if he's planning. I don't see that he's withdrawn yet, and just let him know when this hearing is going to take place tomorrow. And then someone from public defense can be there on the new charge. On the older charge, 805 case, all conditions remain, set bail in the amount of $25,000, cash or bond. And that one will be, all conditions remain. That'll be on for trial confirmation tomorrow.
I'll certainly let Mr. Pilon know. Thank you, Your Honor.
Thank you. That's it for today, ma'am. You can be taken back. So now, out of Nisqually, in the orange shirt, what's your name, sir?
Clayton Grant?
You've been out on warrant status also.
Yep.
So Ms. Myers, it doesn't look, does he have an attorney or did his attorney withdraw?
Your Honor, I don't believe he has an attorney at this point in time. From my understanding, I'm not sure if we were ever appointed on this case. But it would be our request to be appointed today.
Yeah, you were appointed back in 2022.
There was a withdrawal on the 2nd of 2024.
Okay. So, Mr. Grant, I'm going to reappoint Thurston County Public Defense to represent you. And then we'll figure out where we're headed from here. Mr. Weston?
Your Honor, the state would ask for a warrant, $1,000 each case, so a total of $2,000. All prior conditions remain basis, 2 active warrants, been out for some time. Cases are what, 3 years old, nearly 3 years old. So the state has concerns about whether he would actually appear.
Ms. Myers?
Your Honor, we would be asking that he be released on PR. He has all but 4 things on his criminal history. I asked him about why he missed court. He acknowledges that he missed court, cannot remember the reason as to why. But when his warrant was to the 3 warrants that he has are 2 of these active ones right now. So there's not a huge criminal history we have to worry about. There's not a huge warrant history that we have to worry about. I would ask that you allow him to be PR'd so that he can take care of both of these matters.
So do you have an address right now, Mr. Grant?
No, I don't.
Have you been around Thurston County here this whole time?
No, I just got here 2 nights ago. I'm going to find a mission probably.
Say that again?
I just got here a couple of days ago. I'm going to go find a mission or something probably.
Where you been?
Oregon. Had to leave Oregon. I chose to leave Oregon, but I didn't know how it goes.
What's alleged to have happened in these cases?
Does the state still have any idea? Let's see. Give me 1 second. No contact with the alleged victims in either of the cases, Your Honor.
So the problem I have, Mr. Grant, is you were here, you were released, you missed court, brought into custody, released, missed court, and then now here we are again. And to be frank with you, I'm worried about. I don't know what's going on in Oregon or why you had to leave there or why you chose to leave there, but with that pattern, again, I'm just not. How can I have any confidence I'll see you again if I just let you out and give you a court date?
Oh, I guarantee I'll be in court. I want to do that. I promise. I know what happened. I'm not worried or scared about it. I'll be in court on that day. I just got to make sure I'm getting better at being able to do that. I mean, it's been a long time. I've been on the street for 10 years, but I think I'm getting better so I can, do that stuff. I remember I got a court date and get to it. Other than that, I wasn't doing anything bad on purpose. I was just not remembering to get to court or whatever. I mean, I forget.
When did you come back into Washington? How long you been back here?
I've been here a couple of days. You guys not want me in Washington? Or I mean, does it matter? Or, no offense or none, but I'm not trying to be.
No, I'm just being conversational. I'm just trying to find out a little bit about you.
I've been on 101 in Oregon for a long 10 years, and I'm going to try to Washington.
How'd you get up here from Oregon?
Walk, on the bus. Bus stop all the way here from Astoria. I'll stay around here for a month and go to court. I'm on it all. I mean, there's no big deal. I know what happens. It's in either case. There are 2 taps on one people's shoulder and one on the back of the head. They're taps. I mean, I didn't.
I don't want you to talk about that.
Oh, all right.
So, Mr. Grant, Ms. Myers, Mr. Weston, I'm going to set bail in the amount of $500 in each case. All prior conditions remain, and I would direct the state to see if there is position to go forward in these cases, given the amount of time that has passed. And I can set these on for 1:30 through the 1:30 calendar on Friday. Ms. Myers, if you think someone from your office can be ready to discuss with the state the status of this case going forward.
Your Honor, we can make that happen, certainly.
All right. We'll see you back here on Friday there, Mr. Grant. That'll be it for today. You can be taken back.
Am I released there, or I stay here until Friday?
No, you'll be held at least until Friday.
All done. I'm done with you guys. The end. I've never fucked around this store. Piece of shit.
And then the other in custody on the calendar is
Yes, Your Honor. He is here. We're about to pull him into the booth. I believe he would like to proceed pro se, is the representations he's made.
Yeah, I want you to stay there though, Ms. Myers. Hey, what's your name, sir?
What's my name? John.
Yes.
No.
Okay.
DOE. Date of birth, January 11th, 1963. Social
Okay.
insurance, 477-491-542.
I'm not. So, Ms. Myers, did you discuss with him his legal rights or no?
I do not, Your Honor.
Okay.
It's okay. I would like to represent myself. Through this way, there's no chance of a mistrial.
Do you have an address?
Actually, no, I don't.
Okay. Do you have a cell phone?
Job, lost it all, wound up on welfare, lost my apartment, and was forced out in the street.
Okay. And so do you have a cell phone?
No. I've never actually used it. If you're talking to ones you carry in your pocket, no. I had a cell phone once.
So you're now charged with 2 crimes: obstructing a law enforcement officer in the performance of his or her duties, criminal trespass in the 2nd degree. Anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney. If I can't afford an attorney, one will be appointed to represent you at little or no cost. You have the right to a trial by jury in the county where the crime is alleged to have occurred. You have the right to hear and question witnesses called by the
prosecution. I was on the side of a highway. I wasn't aware the highway was a county.
Okay, so hang on just a second. Let me finish, sir. You have the right to hear and question witnesses called by the prosecution. You have the right to call witnesses in your own behalf, and I can require the attendance of your witnesses.
I don't have any witnesses. All you have is me.
You know, we'll get through this a lot quicker if we agree not to interrupt each other. And so let me finish, and then when I ask you questions, I won't interrupt you either, okay? And you're presumed to be not guilty of the crime charge. You cannot be found guilty unless this prosecution proves the elements of the crime beyond a reasonable doubt, or unless you enter a plea of guilty. You have the right to remain silent. You're not required to testify against yourself. At the same time, you do have the right to testify on your own behalf if you choose to do so. Finally, if you take this matter to trial and lose, you would have the right to appeal your conviction to Superior Court. I'm going to swear in the prosecutor. I'll hear from him with regard to probable cause. Could you raise your right hand, please? You swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do. On September 22nd, 2025, Thurston County, Washington State Patrol trooper was on patrol in Thurston County at about 7:12 a.m. Dispatch advised of 911 callers reporting a male pedestrian on northbound I-5 near milepost 91. Their callers reported that the pedestrian was throwing objects at passing cars while en route.
Say that again.
The pedestrians reported to 911 that the callers reported to 911 that the pedestrian was throwing objects at passing cars on the freeway. Upon arrival, troopers observed the white male wearing a baseball cap, tan jacket, blue jeans, walking northbound on the right shoulder. This was consistent with the description the callers had provided. One of the troopers pulled up behind the individual, turned on his sirens, but the individual continued to walk away. Second and third trooper pulled up behind the first trooper. One of the troopers utilized his PA system and gave commands to the individual to stop walking and advised that he was not allowed on the freeway. The subject turned and gestured with his middle finger before continuing to walk northbound, away from troopers and ignoring commands. Eventually,
I did not give the troopers my finger.
Eventually,
to somebody turned, looked like they were going to run me over.
Okay.
In which case,
so you need to. Okay, just let him finish, please.
Eventually, after several attempts, the troopers were able to get the subject to lay on the ground and into a safe handcuffing position. At that point, he was subsequently arrested for criminal trespass and obstruction and brought to Thurston County Jail.
Okay. So, Mr. Doe,
I had gotten a morning coffee and I got scolded by it. I was really mad. I was in the process of lighting a cigarette. I could not believe walking down there with a scalded ankle and part of my fingers burned trying to light a cigarette that I'm doing in time in jail.
have you ever gone by any other names besides John Doe, or is that the name given to you at birth?
That is the names on my birth certificate. There's nothing I can do about it. I don't like it, but that's the way it is. John J. Doe.
Okay. And then how long have you lived in Thurston County here?
I was just passing through it.
I see.
Somebody told me the highway was classed as the dead zone. I was not hitchhiking.
Okay.
I was having a smoke. My ankle was burned. I was really upset. And I can't understand, while having a smoke, to calm down, what I was arrested for.
That's not necessary. Again, these are just allegations, but that's not necessarily why you were arrested.
I was upset. I was mad because my ankle was burned when the coffee spilled on me. I kicked what was left of the cup because it had already spilled on my foot and my leg. I was very upset. I had a cigarette, trying to light it on the side of the highway, could not believe I was being arrested for spilling a morning coffee. That is unbelievable. A criminal record because you had a cup of coffee, left it by the lid, a drop spilled on your leg, you kicked the rest of it, walked out, took a cigarette butt to have a drag, and I'm arrested for it. That is unbelievable.
Well, you've been charged with a crime. As I said initially, you have the right to an attorney. I'm told you're not interested in having an attorney appointed to represent you.
Being arrested for having a hot coffee spilled, he dropped the lid when I had the lid I thought was fastened on tight. It dropped on me, spilled on me. I kicked what was left of it because I was mad from being burned with scalded coffee, walked out, lit up with smoke, could not believe I'm being arrested for spilling a hot coffee on myself.
Where was this alleged to have occurred? Did you say this was on I-5?
Yeah, I-5 northbound by the Scatter Creek rest stop area.
I bought a coffee. I paid for that coffee.
Okay, so I'm gonna speak for a minute, and I hope you don't interrupt me. But spilling the coffee is not why you were arrested. Now, these are just allegations. Nothing's been proven beyond a reasonable doubt. But you were arrested because it's alleged, and again, these are just allegations, that you were throwing rocks at cars and were walking on the freeway where you're not supposed to walk. You're not allowed to walk out there.
Walking in the ditch. I walk over by the rail or in the gravel as far as I can get away from the traffic because I'm stupid enough to walk in the center of it. That is just begging. That is suicide and murder, which is completely stupid.
Well, you're still not allowed to be there, no matter where you are out there.
I'm not allowed to be on any road of any kind? Is that what you're saying?
No, not on the interstate freeway and the interstate highway. No, you're not allowed to be out there. On other roads, yes, you can walk along the side. And again, these are just allegations. I want to emphasize. And if it's alleged you were out there in the freeway, yeah, you're not allowed to be out there. So I'm trying to figure out where
a person has no right to life. Thank you for telling me my body belongs in a jail. I do not have any civil rights as a human being. Thank you. No different.
I'm not saying that. I'm trying to figure out where we go from here. I haven't said anything about whether you're going to be held or not held or anything
I
like
have
that.
no civil rights as a human being. I don't have a right to my own mind, my own body. It's what you're saying.
No, that's not what I'm saying.
It is.
Okay.
Difficult. Just like everybody else. Anybody else can do whatever they want. But you can't have a name like that's not like anyone else's. Anything. Thank you. Yes, I understand why I'm in jail now. I don't have any kind of civil rights. I'm not even voting. Thank you for reinstating that.
Okay, so Mr. Mr. Doe, here's what's going to happen here today. As I've said before, I found probable cause for obstructing a law enforcement officer in the performance of his or her duties, as well as criminal trespass in the second degree. I am going to appoint Thurston County Public Defense to represent you based on my conversations with you. I'm going
Thank you. So now I don't have rights to represent my own self, so I don't have a brain. Thank you.
You have a bail's going to be set in the amount of 1,000 cash or bond.
Ain't no words in me in the back.
Okay. Bail be set in the amount of $1,000 cash or bond. If that's posted, he'll be subject to a DCR review. The conditions are don't have any criminal law violations. Based on my conversations with you, I have concerns about your competency to proceed forward. I do that. I'm going to order a 1077 evaluation. Ms. Myers, I'll rely on you to prepare that to me. And we'll set a hearing 1 week from today at 1:30 to see where we're at. If we get an evaluation and go from there. And again, this is my motion to order that evaluation. And that's just based on the conversation that we've had here today. And so you can be taken back, Mr. Doe, and we'll see you 1 week from today.
That's it.